It's Nick Wooten again, Consumer Trial Lawyer Academy. We're here to talk about what we do in the lead up to drafting our complaints. And this is what we usually do between the time when we've interviewed the clients and had initial meetings with them. They've gone through our multiple layers of review, and then what we do when we get to our place where we've got to decide, what is our complaint going to look like and how are we going to file suit, that sort of thing. So, two things become important. Excuse me for quenching thirst. First, we need to gather all the evidence we can from our client's own documents. If you are doing mortgage servicing litigation, then that can be voluminous. If it's some other type of case, such as a fair debt collection case or auto warranty or something of that nature, maybe your documents are not so voluminous. You're not going to end up with thousands and thousands of pages like we do in mortgage servicing cases. So obviously you got to identify the critical documents for your clients, and you've got to work with them and get those documents gathered from what you have. But remember that what you have is, a fraction of what you'll ultimately have in the case if you go to litigation. So what you're looking for then is the next step beyond, what your client can give you. And if you're if you are doing a mortgage case, then you may have the ability to use RESPA to seek additional information from a defendant. You can always write that request for information, that notice of error. And, since the CFPB has become active, the response rate is better. You're still going to get jerked around to some extent about, what you're seeking. There are a lot of schools of thought about what to ask for. I would tell you that, I'm a proud graduate of Max Gardner's boot camp, and Max used to, send a QWR that would, or a request for information that would choke a mule. I mean, they'd ask for a million things. And, I think some lawyers in the past have been guilty of asking for everything plus the kitchen sink. I don't think it's effective. I think if you really want to get good information pre-litigation, you really have to be very targeted and specific to your case. In addition, the more you know about the particular target of the litigation, especially in the context of mortgage servicers, we tend to know what software systems they use. We tend to know what information they have that we can use that's relevant to our cases. And we also typically know the quote-unquote magic words, the language that they use to discuss particular documents that they have in their system. That comes from taking many depositions of these various defendants over many years. But the more specific and targeted you can be, obviously, the better quality of information you should get in theory. And of course, if they don't give you the information they should have, well, that also becomes useful later when you proceed with the case. The other thing you want to do after you've gathered all of that type of information and, a very targeted notice of error sometimes leads to a series of communications, which sometimes leads to resolution. I do know a few lawyers who've been able to resolve some cases without having to go deeply into litigation. Kudos. Just doesn't happen much, but to anybody who's ever been successful convincing Aquin to do the right thing, more power to you. They never do it for me until I stomped a mud hole in them and walked it dry. So, in our own circumstances, what we're looking for is everything useful that we can get confirmation as much as possible, because generally, the rule in our office is, and has been with me personally for a long time, is I just don't file a marginal case. So when I go into a case, I generally know, if I prove the facts that I'm alleging, I'm going to win the case. And, to do that, you have to answer most of your questions really pre-suit. And we work real hard to do that. And, of course, another thing that we do in our investigation is we look for consent decrees, settlement agreements, consent judgments, regulatory orders from state and federal regulators. That's especially true with mortgage servicers. Some of these folks, we've got consent decrees going back 15 years, all the way to sort of initial wave of settlements after the start of the financial crisis in circa 0809. And some of those consent decrees track all the way through to basically present day with certain companies and actors who have not yet been able to get their program together. So you take all those things and you try to put those things together so that this is my evidence, this is what I know I can prove going into litigation. And what you're looking for when you start the case is, what can I not prove? And in theory, if there's anything that you can't prove, it's not something that really matters ultimately on the merits, or it's something that you have a strong sense that if it's in the air going into litigation, what you know about the particular point leans very heavily in your favor. So the idea being, file the cases with summary judgment facts. If you don't have summary judgment facts, then what you're looking for is a strong sense that anything that's you don't already know the answer to is going to come down in your favor as you work through discovery and you begin to take testimony and that sort of thing. So that's always hugely important in what we're doing in the run-up to our complaint drafting. And that sort of the complaint drafting process becomes the culmination of our very in-depth intake and then our extensive document gathering and investigation of the defendant. When you're talking about consumer, again, higher level of complexity in most instances than an 18-wheeler running over a car full of kids. Just, there's a lot of complexity in that work, from the things that you need to know in its own right with respect to all the things you have to find out about compliance with federal motor carrier safety regulations and how many people are involved in shipping this load and who all are your defendants and that sort of thing. But at the end of the day, your dispute's pretty simple. This 18-wheeler ran over this car full of kids. The gathering of the evidence after litigation begins is much more intensive in that setting than in the consumer setting, where you can get a lot of what you need before you file suit. And in the context of what we do with consumer law, we try to spend a lot of time and effort making sure, at least in my firm and with the people that I work with around the country, that we know going in what we're up against, and we know if there are open questions, what they are. And again, we have a strong sense that those questions cut in our favor, or else we just don't go forward. A good friend of mine said one time, it takes the same amount of effort to do a $10,000 lawsuit as it takes to do a $10 million lawsuit. And you just don't spend time on bad cases, spend time on good cases. And that is a truism. Also, don't file marginal cases. There's lots of reasons not to. One is you might spend a lot of time and not get paid. which is a terrible waste of your time and a hard way to learn an easy lesson. The other is that, you know, those types of cases are the ones that keep you awake at night, because you are spending a ton of time and effort in a situation where you don't necessarily have a high degree of confidence about winning. So, you know, be brutally honest with yourself, be brutally honest with your team and your colleagues and co-counsel, and do the work to know that you're filing a solid case on the front side, barring some, you know, just drastic change in the evidence or testimony or something. But, you know, these cases generally should be filed in a format where they're very strong. We'll talk a little bit about complaint drafting in another video. Trying to keep these short and impactful. So thank you for joining us again. If it's been useful, any comments, like and save, like and subscribe, whatever it is that YouTube says do, please do so, and we'll do our best to get answers to you if you have questions, and do all we can to try to address the various levels of things that may be out there through this process. Thanks, and see you soon.